good day. My name is Teresa Fredericks from Growing Businesses Using Projects, bringing you the second video on the implementation of the Procurement Act of Trinidad and Tobago, and we are looking at unsettled issues. We are in part 2, and we are saying there's too wide a scope. I'll explain more about what I mean when I say the scope is too wide as the video progresses. Our agenda, we're going to be looking at the proposed framework, procurement framework, the concept of public money, the definition of public bodies, the duties of the Office of Procurement Regulation and the regulator. The span of control is too wide. That's my statement. It's my take on the OPR's ability to effectively perform its wide range of functions given such a large target group. I'm saying also we're talking about focusing on what matters, capturing and ensuring that the big procurements are properly accounted for, and suggestions of a way forward. All right, so what is the proposed framework? A framework in which there is greater accountability and transparency of expenditure of public money on property and services. There's greater efficiency of implementation of government policies within the context of best practice, best procurement practice. Public confidence in the manner by which government conducts its business, particularly in the acquisition of property and services. Ethical conduct of all parties in the procurement process, thereby engendering mutual trust and respect. The responsibility of Parliament in the procurement process. Equal opportunity for bidders and greater confidence in decision making. Inclusion of other financial arrangements such as build, own, operate, transfer, build, own, lease, transfer, design, finance, construct under the legal and regulatory framework. So what are we saying is that we were putting in place a legal and regulatory framework that will give us these results. And I had forgotten to talk about the fact that under the CTB, these kinds of financial arrangements did not come under its purview. But in this new procurement framework, all types of procurements, whether it's tendering, BOLT, DFC, whatever it is, all falls under this act. So in order to bring and to ensure that all the money is captured, the government used a term called public money. It's a term used to get away from problems whereby new state and other agencies and other persons or organizations spending public money are not under the purview of the Act. So that the new types, as again, of design, build, and other procurement arrangements that were not under the Central Board Tenders Board is now under this Act. Procurement, public money, attempts to capture all expenditure, and not only that, even gifts. You heard in previous years people talking about is the Chinese money and it's this money and that money, whatever money is captured, it is under this act from however it was given to the government. So when we talk about public money, we are looking at money received or receivable by a public body. So it's received from the Chinese by the public body, it's under this act. Raised by an instrument from which it can be reasonably inferred that the state accepts unlimited ultimate liability in the case of default. So that if an organization borrows money, but if they cannot pay, the person to whom the debt is incurred, they are going to move against the government for payment. Spent or committed for future expenditure by a public body. So if as has happened on the eve of an election, somebody goes and commits or signs a contract that has to be now fulfilled by whoever is coming in, distributed by a public body to a person. The reason I underline this, it brings in individuals. So it's not just people thinking the act is only for ministries. It's not only for ministries. It's all persons who receive public money also. So that's D, raised in accordance with a written law for public purpose appropriated by Parliament. So it avoids us having to go back and amend to put in new people or new bodies that are now under the Act. So that this brings in the NGOs, non-government organizations, the FBOs, faith-based organizations, the CBOs, community-based organizations, all these organizations that are given money to do work on behalf of the government. So let's talk a little bit about public bodies. A municipal corporation established under the Municipal Corporation Act, a statutory body, responsibility for which is assigned to a minister of government, a state-controlled enterprise, a company incorporated under the laws of Trinidad and Tobago, which is owned or controlled by the state, a company incorporated under the laws of Trinidad and Tobago, which is owned or controlled by a company referred to in paragraph 8 and 4 I'm taking from the Act, a body, corporate or unincorporated entity which is supported directly or indirectly by public money and over which the state is statutory body, or a company referred to in paragraph 4 of this section, or B, is in a position to exercise control directly or indirectly. You can go into the Act and you can get a little bit more of public bodies. So this is the span of control that the OPR has to address. So what are the duties? The OPR and the office and the regulator, so this is not just of the office but also of the regulator, reports on the performance of the procurement and disposal function, monitors the procurement of goods, works and services and the disposal of public property by public bodies to ensure compliance with this Act, conducts audits and periodic inspections of public bodies to ensure compliance with this Act, issues direction to public bodies to ensure compliance with this Act, and carries out such other activities and do such other acts as it considers necessary or expedient for the carrying out of its functions. It does not end there. For upon complaint from any party involved in public procurement or disposal of public property or any other member of the public, any alleged or suspected breach of this Act, it can audit and review the system of procurement and disposal of public property to ensure compliance with the objectives of the Act. It advises on best practices. It establishes a comprehensive database of tenders and awarded contracts. It sets training, standards, competence level, and certification level requirements. It issues guidelines on the retention and disposal of public property. It prepares model handbooks with standardized bidding documents. It promotes public awareness. It promotes the use of technology in the procurement and disposal function. So you would realize it has a wide range of duties and responsibilities. But we've been talking procurement and we hadn't been paying much attention to the second aspect of the Act, which is disposal of public property. So when we're talking about public property, we are talking about real property and personal property. So in terms of real property, you have land, buildings, heavy machinery, trees. In terms of personal property, you have tangibles, you have furniture, equipment, vehicles, goods, materials, light machinery, tools, vessels, and collectibles. Intangible, you have intellectual property, patents, trademarks, and copyrights. So all of this comes under public property. And in terms of methods of disposal, you can recycle, you can cannibalize, reuse, you have public spot sale, you have public tender, you have donate gift, you have destroy or dump, you have concession or lease, public auction, trading, transfer, selling to the employees. Now, the OPR is not doing all of this. This has to be done now by every agency, every ministry. So I'm saying the span of control is too wide. Why? The OPR is looking at public bodies, the agencies, etc. It has to look at civil society organizations that receive public money, organizations and persons who receive public funds for public purposes. In addition, it has to look at the entire procurement and disposal of public property cycle, not just as the CTB. And remember, CTB had some serious staffing issues. And now we have an organization that is not just dealing with what CTB dealt with, which was tendering, but is dealing with the whole of procurement and disposal. It has to do performance management and reporting on the operations of the procurement function. It has audit responsibilities. It has administrative responsibilities with respect to those who have to report to the OPR as well as to the suppliers. Answering to government questions raised on the procurement system. And in this environment, it seems people are asking questions about everything. Oversight of large projects funded by different agencies all over the country. So it forced me to ask, when I look at the duties, when I look at how many, everybody that falls under the Act, it forced me to ask a question: what are we trying to do as a country? And I'm saying we should be going after the big fish, not the small fish or the fingerlings or something like that. We have to focus on procurements that matter, read dollar and impact. So what are suggestions of a way forward? I'm saying think thresholds. If you want to keep everything under the OPR, is there a dollar limit or value or something that you could use as a threshold? For instance, some of those who receive above a certain amount is going to come under the OPR. Now remember that there are existing laws in Trinidad and Tobago, and we have to remember that. So if there's fraud in an organization, if it is within the purview of the OPR or outside the purview of the OPR, the existing laws will kick in. All right? Think of the role of government ministries with respect to those agencies, etc., that it controls. It may be possible that we're going to have a lot of the organization and the control systems, etc., at the ministry level, and not have every agency having to set up big procurement departments. We have to look at what percentage of the budget of those agencies really go to procurement. And as a cost center, could it justify having a procurement department? Think about relaxing penalties during this phase of implementation. It's almost like teaching somebody to do a 4-course meal, and then you penalize them because the first time they try, they do not succeed. Think about setting up an implementation committee outside of the OPR, but with the input from the OPR to catch and deal with implementation issues during a phasing period. Think about local government reform, and I'm going to show in the next video my view of the role of the local government in the procurement framework. If you like my content, give it a thumbs up and please subscribe, and look forward to other videos.